Hello, all. Welcome to another session of Legal Essentials for Human Resource Management. This is week 8 and session 36. And if you have made up to this session, it means that you have successfully completed 7 weeks in this course, and we are here in the final week of this course. So, many congratulations if you have reached till this point. If you remember the arrangement of lectures of this course, it was arranged in such a way that we follow an employee life cycle. And we started off with employment contracts, how to fix wage. Then we looked at how to provide proper social security and well-being, which are, some of them are assured by the existing labor laws of the country. Then what if the workers or employees doesn't feel happy at their workplace by the social security or wage or the well-being provisions given to them? Then it will go to industrial dispute, and we have looked at what kinds of industrial dispute exist and how to resolve it. Now we will get into the end portion of employee life cycle, where we would be looking at termination of employment, how to do it properly, how to do the full and final settlement after termination, and we'll also discuss in detail one of the major grounds of termination, which is misconduct. So either the employee would be willingly leaving the organization due to personal reasons, or because he got another job which he prefers, or it would be because the employer decided to remove this particular employee or worker, citing a misconduct. And if you have listened to all the sessions till now detailed, you'll realize that labor laws have given utmost importance to this concept of continuing in employment. Every aspect of employment, the dispute says that you have to collectively raise it, then only it will become an industrial dispute. But when it comes to termination of employment, even a single case becomes a case of industrial dispute. Also, courts over and over have defined and redefined right to work at par with right to life. We have discussed that in the first week of this course. So, you forcefully removing a person from an employment is a risky affair until and unless you don't follow the existing compliant mechanism. And most of these industrial disputes are often a dispute regarding termination of an employment. That's why I have dedicated some good number of sessions to actually see how to properly follow a procedure of identifying a misconduct, providing a charge sheet, then conducting a domestic inquiry, and then how to terminate an employment. So we will be following entire legal aspects in this week. So without much delay, let's get into our session 36, where we are going to talk about what is employee misconduct and what are the various types and consequences of employee misconduct. And I hope you know my name by now. I'm Dr. Ramesh Samalopanan, and I'm from Nalsa University of Law, Hyderabad. Now, what is misconduct? So, there does not exist a proper legal definition of employment misconduct, but what I could gather from existing literature as a definition would be that it's a improper or unacceptable behavior. So that's the key to it. It is improper. It is not a proper behavior, or it is an unacceptable behavior. It is improper or unacceptable. So that assessment is based on the nature of the act or omission. Let's say you forgot a stapler, right? You went to have a tea in a nearby restaurant. There you forgot a office stapler. probably will not face a serious misconduct inquiry, or there would not be it won't be deemed as a misconduct. But there was a very important file which is supposed to be classified, and it includes all those secret formulas and recipes that you are having, and you forgot that in a restaurant. Same act, you forget a item, you forgot a object. That's what happened. But you'll realize that for the first case, it may not be deemed as misconduct, but in the second case, it would be a misconduct because of the nature of the act. Second would be its impact. So, I'm just giving you casual examples. So, the stapler you forgot. Let's say it was not an issue in the first case. Remember, you forgot a stapler. Nobody cared. Nobody even noticed that one of the office staplers are, missing. But let's imagine there's a huge shortage of staplers. Nowhere in India there is an availability of stapler, and this is like one of the rare staplers. And also, for your for your work at your workplace, stapler is a must. So you have to staple paper and give to customers. It's a very integral part of the work. And your work will not, at your workplace, there are around 60-70 employees, and any work in your workplace will not happen without a stapler, and you lost that stapler. So the impact is huge. In the first case, it was given away because the impact was not huge. No impact happened because you just lost a stapler from your office. But in the second case, the impact is huge. The third reason would be the intent behind it. Let's say you lost a stapler. In fact, you threw it away, threw the stapler away. You didn't lose it. For the workplace, the impact is same. They lost a stapler. But some of your colleagues saw that you had not accidentally forgotten it, but you in anger threw it away, and they reported it to the manager. And the manager just did a preliminary inquiry and realized that you have this habit of picking up office supplies and throwing it away. Now manager is making a case out of it. Why? Because your intent was bad. Okay. It does not have any major impact at the workplace, and the nature is also nothing serious. It is people often forget staplers here and there, but your intention was bad. So that's a misconduct inquiry that has been taken. So let's look into. So I hope now the definition is very clear. So any improper or unacceptable conduct or behavior, and which is assessed on the basis on the nature of the act or omission, its impact or intent behind it. Now let's look into all these aspects one by one. Nature of the act or omission. What is it? So it must be a wrongful behavior or a improper conduct on the part of the employee. So it should be a wrongful behavior. So that's the nature. So let's say an employee coming to office late once or twice because of heavy traffic may not be considered a misconduct, because an act cannot be considered as a serious offense. There could be a contextual issue here. So I'm giving this example because you also need to take in context to determine whether it is a misconduct or not. But this guy comes late every day. So definitely there is no excuse here. It was not because of the traffic. It's because the person's nature is of a wrongful behavior type. Then it becomes a misconduct. Another way to determine whether the act is of a nature of misconduct, or it's an improper act, is comparing it with the existing uh, service regulations. So if there is a mandatory condition in the service regulations that this has to be done, and this person has not followed it, that also can be considered as a misconduct. So, for example, if the contract requires employees to perform all the duties assigned by their manager, but the employee blatantly refuses to perform the assigned duties, now in another context, probably it may not attract misconduct provisions, but here in our workplace, it was very clear that the basic expectation of the employee is to perform all the duties given by his manager, and he has violated it, and now it becomes a misconduct. The impact of the act or omission, by which it means that impact of the act or impact of not doing an act, that can also be a ground of misconduct. For example, because of your act, a huge loss has happened to the employer. Or let's say, even if there is no loss, if the act or omission is prejudicial or likely to be prejudicial to the interest or reputation of the employer, like your employee came in social media and badmouthed a particular brand with which you have a long-term agreement, and that video went viral, saying that this particular brand employee wearing that brand T-shirt is abusing another brand, and the entire Twitter, X, Facebook, Instagram is buzzing with this video. Nobody knows the employee's name. They're all focusing on the T-shirt the employee is wearing, where the brand's name is there. Now this has created a problem. That cannot be a misconduct. If by the particular act they created an atmosphere that is destructive of discipline. Now this person called out certain names. Now suddenly there is two factions in the workplace and it's like a riot-like situation at the workplace. Then that also becomes a misconduct, because the impact your act have created is huge. Anything that is detrimental to the prestige of the institution, put the employer in any kind of embarrassment, or the act is a reflection on the employee's character. This has nothing to do with employment, but it kind of reflects the employee's character. He's been found stealing, not in the workplace, but from another workplace. He went to a jeweler and he was caught trying to steal something, or all those kind of things. That can also be a ground of misconduct. And most important is the intent behind the act or omission. So the general rule is that the misconduct must be willful in character. That is, there must be some intent on the part of the employee to commit the misconduct. Like the stapler example, he forgot. There was no willful interest in doing it. It was mere an accident. Then most cases you don't call it under misconduct, but there are exceptions. For example, Union of India versus J. Ahmed case. UOI is Union of India. So in that case, Supreme Court, while deciding the case of gross or habitual negligence of duties, held that even in the absence of mens rea, which is guilty mind, so that's a Latin phrase which says ki even if you didn't have the intention to do it, even if you didn't have the guilty mind, the employee's action, if caused a considerable consequences, and these consequences can be directly attributed to the employee's action, then it can still be called as a misconduct. Now, what are the types of misconduct? Is there a list which tells us what are the various types of employee misconduct? Now, to come to a conclusion on this, what we can look at is the model standing orders. So, if you remember our initial sessions, we had a class on standing orders, which I said that every factory, every establishment should have standing orders, which explains what are the basic rules and regulations at the workplace. And we also discussed about a model standing order, which is given by it is available there, and you can download it, and if you want you can adopt the model standing order yourself. And if you adopt yourself, you don't need to get it approved, but if you make any changes or you draft your own model, your own standing orders, then you need to get it approved. And also we had that discussion before. So model standing orders, if you can look at, and it is often drafted by the respective state governments under Standing Orders Act. So there are always certain acts, and omissions which are considered as misconduct. So you can look at that list. So most of the state, if you look at standing orders, you will see that willful damages or damages due to negligence or carelessness is a misconduct. Bribery is a misconduct. Insubordination is a misconduct. Theft, fraud, or dishonesty is a misconduct. So unauthorized absence or habitual absence is a misconduct. Riotous or disorderly behavior is also a misconduct. Habitual late attendance, another misconduct. So this gives you an indicative list of what all can be called as a misconduct. And some of the grounds are unique to certain states. For example, in West Bengal, model standing orders, they say that lending or borrowing on company premises is considered a misconduct. So in that way also there are some changes, but I hope you understand that one way to define what are misconduct, and one of your employees were caught in habitual late attendance, and then you decided to take a disciplinary action, and if he raises on what grounds have you said that coming little late to workplace is a misconduct, you can cite model standing order. So that's the whole purpose of this argument. But being said that, employers can also define additional grounds of misconduct. So model standing orders are orders is there, and in that a lot of acts or omissions are called as misconduct. But let's say this particular employer want something more, like for example, let's say not indulging in caste based discussions at a workplace. Me as an employer doesn't like. Can I just include this as a misconduct item? So this discussion happened in MS Dhantwal versus Hindustan Motors case. So Supreme Court was deciding on whether termination of employment was due to a misconduct or if the termination was a simplicity. So as in like Mr. Dhantwal went against Hindustan Motors saying ki I've been terminated and there's no grounds on it. They just randomly terminated me. But the company was saying that no, it is on the basis of misconduct. So the legal counsel for the employer submitted that termination can be said to be misconduct only if the misconduct is enumerated in the standing orders of the employer. What the counsel was arguing is that only those things which are mentioned in the model standing orders as misconduct can only be called misconduct, and whatever this person have done is not there in the model standing order, and hence it's not a misconduct. Then Supreme Court said no, standing orders of a company only describe certain cases of misconduct and cannot be exhaustive of all the species of misconduct which a workman may commit, and hence the misconduct may not be limited just to the MSOs. So, see, in a standing order, you can only give indicative list which the employer expects that employee would be possible to pull off. But technology is improving. There are various ways by which you could indulge in an act which is unacceptable by the employer. Hence, it's impossible by the employer to list out all the things. So that's what the court said, that no, it doesn't have to be in the standing orders, necessarily doesn't have to be in the standing orders to be called as a misconduct. But later in the case of Glaxo Laboratories Limited, in that particular case, the court said that even though it is not there in the standing orders, there is a need for the employers to draw a boundary regarding what would be activities that will be counted as misconduct. For example, let's say AI is developing, and we said that any frauds using internet is a problem, or any softwares is a misconduct. Now this guy brought in a new AI based system where there is no computer used, but it was a mobile, and there's an AI thing, and it's not a software, it's something else. And then he's arguing, no, it was not mentioned. So that becomes counterproductive to what misconduct definitions are. So that's why in this particular case, the Supreme Court said that while you don't have to have the exhaustive list of all the disciplinary things, you should have an indicative list of what all could be a possible misconduct, and you cannot do it ex post facto. Like, I hate this particular person, and he sat on a red chair, and then I'm saying, sitting in the red chair according to us is a misconduct, you are fired. So that should not also happen. So even if not specific, an indicative list of misconduct should be given so that the employee have an idea that what would be perceived as a misconduct in my particular organization. Now, in this particular case of Glaxo Laboratory, what happened was the counsel, appearing on behalf of the employer, relied on the observation made in the Dhantwal case and argued that can be some other misconduct not enumerated in the standing orders for which employer can take appropriate action. So that's what Dhantwal case said. Not all the misconduct can be listed in the paper. So even if it is not there in the standing order, employer can call it a misconduct. But here Supreme Court brought in a clarity on this matter. It said that it cannot be left to the management to say ex post facto that some acts of omission nowhere found to be in the standing order is now a misconduct. So the best way to do it is to have a disciplinary policy which kind of gives all the indicative list of misconduct and also clearly says that anything that leads with this. So theft using computer versus theft in any form is a much more broader way to put it, and it will give you that scope of explaining that you use any kind of method to do a theft, it would be a misconduct. And of course, when you come across such things, you can incorporate this into existing standing orders also. And if you remember, standing orders, changing the rules is a change in service conditions. So 21-day notice has to be given. We have discussed this in prior to these sessions. We are discussing how you have to give a notice before you change any service conditions. So moment employer observes something that can be deemed as a misconduct, and probably he realizes that, oh, that's a gap in my existing standing orders, he can change the service conditions by giving a prior notice. But the whole essence of defining what is a misconduct is also understanding that it should have some connection with the employment. So a classic case is Baleshwar Singh versus the Port of Calcutta and others. So it set out a list of matters that are unconnected to the employment but would still be considered as a misconduct. So the whole idea is that the act or the omission that you involve in has to have some relationship with the employment. But it also doesn't mean that you're not doing this particular activity inside the premises but outside, means that it's not an employment issue. Like, you had a grudge with your coworker, with your manager, because he is asking you to follow the rules, and because of that you came out of the workplace, you are waiting outside until the manager comes out of the workplace premise, and then you physically assault him. You cannot argue that it is not related with the employment. So in this particular case of Baleshwar Singh, the court put out a list of matters that may look unconnected to employment but can still be considered a misconduct. So, first, if the alleged act reveals the character of the servant, such as dishonesty or gross immorality. I told you he was stealing in another shop. He was physically assaulting a female in a different setup. It kind of shows you the character of the particular employee, and you can take it as a ground of misconduct, ground of termination, and then start a procedure, a termination ka procedure you can start. If the servant is guilty of such crime outside his employment as to make it unsafe for the master to keep him in his employment. So major crimes he is involved. He has not done it here. Imagine you realize that your employee is a serial killer. Now he cannot argue ki in employment section I am a very calm person. I come on time. There is nothing related to my standing orders that I have violated. What grounds do I have? How can you terminate me? So even if the person is guilty of a crime outside his employment, to make the master or rather the employer to keep him with him, it's unsafe to have him, it can lead to a termination. And whether though the act has happened outside the place of work and does not relate to the contract or service, yet affects the employment indirectly. Like the example I gave, a fellow workman has been beaten up, in a canteen outside the premise of the workplace. Now, such things can also be brought into the purview of employment misconduct. Now, I hope you have a fair idea of what is misconduct and how will you come to a conclusion whether some activity is a misconduct or not. Now you have that idea. I think it's good time to introduce you into the concept of drafting a charge sheet, because that is the next procedure. So we'll discuss how to draft a charge sheet in detail in our next session. Until then, you have a great day ahead. Thank you so much.